Hello everyone, we welcome you back to our channel. This is Legal Mindset at the bar. I urge you to subscribe, share, like, and comment what video do you like next. So, in this one, we are going to look at the offense of manslaughter. It can also be a defense to murder, and this is criminal liability, criminal law 2. So, the offense of manslaughter is technical because there is a certain class of manslaughter where the element of malice aforethought is present. Another class of manslaughter where the element of malice aforethought is absent. I urge you to be attentive because this topic is sacrosanct, paramount, and very important for your understanding of criminal liability, the offenses. So, to dive into manslaughter, remember we said that the principle of legality, Article 28, Clause 12 of the 1995 Constitution, no person, except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed by law. So, if you go to Section 170, subsection 1 of the Penal Code Act, Cap 128, manslaughter is defined as any person who of unlawful act or omission causes the death of another person commits the felony termed manslaughter. That is the definition. So, if you continue to Section 173 of the Penal Code Act, Cap 128, the punishment of manslaughter is that any person who commits the felony of manslaughter is liable on a conviction to life imprisonment. So, to continue, we said that the act should be guilty and the mind should be also guilty. That's why I told you the offense of manslaughter is technical. The actus reus of manslaughter is the act or omission from which death resulted. So, here, the mens rea of murder is not present. That's why we call it manslaughter. There is no malice aforethought. Now, let us dive into the ingredients, the elements of the offense of manslaughter. The ingredients of the offense of manslaughter were clearly and were laid down in Section 170, which states that any person who of unlawful act or omission causes the death of another person commits the felony of manslaughter. Any person, a person who kills another with unlawful act and death. It means we have the dead body should be present, the act must be lawful, and the participation. But these ingredients of the offense of manslaughter were clearly laid down in the case of Uganda versus Arijuna Matia, criminal case number 131 of 2011. So, in that case, court laid down the ingredients of manslaughter. Number one, the death of a human being. Number two, unlawful causation of death. Number three, the participation of the accused person or persons in the causing of death. So, we are going to look at the ingredients one by one, tentatively. So, at the death of a human being, I urge you colleagues to look at the limitation of death. And you also look at who is capable of being killed. The limitation of death in Section 181 of the Penal Code, a person is deemed to have killed another person if that person is not deemed to have killed another person if that person does not die within a year and a day of the cause of death. And who is capable of being killed? Section 108 of the Penal Code Act. A child becomes a person capable of being killed when it has completed proceeded in a living state from the body of its mother, whether it has breathed or not, whether the nervous string is severed or not. So, you can look at what causing death means, I urge you to look at the book of Catherine Elliott, which defines death as entailing the irreversible loss of essential characteristics which are paramount for the existence of a living person. So you can also look at the case of Uganda versus Alijuna Matia, uh, where a court stated that death of a person can be proved by a post-mortem report or evidence of a witness who attended the burial of the deceased. There are many cases, and the case of Uganda versus Anyao Milton and another criminal section number 005007 of 2017, where Justice Stephen Mubiru held that death can either be proved by a post-mortem report or evidence of a witness who proved that they knew the deceased and attended the burial or that they saw the dead body. You can go and continue to another ingredient of unlawful act, unlawful causation of death. What is causation? What is causing death? The act or omission of the accused must be the act which led to the death of the deceased. We shall do a video on causation. So you should prove that the death was caused by unlawful act. If you go to section 170, subsection 2 of the Penal Code, unlawful act is defined as an act or omission amounting to culpable negligence, whether death or grievous bodily harm will happen. And if you look at participation of the accused must be the person who killed. You should prove that the accused was at the scene of crime. If prosecution fails to place the accused person at the crime scene, it means the accused will be acquitted. Uganda versus Dr. Agre Chinji. Dr. Agre Chinji was acquitted because prosecution failed to place him at the scene of crime. We have the classes of manslaughter. We have voluntary manslaughter. This is where the actus reus and mens rea of murder are present, but the accused brings in all killed under circumstances which the law regards as mitigating factors which mitigate the offense of murder. For example, you can raise infanticide, you can raise provocation, you can raise diminishing responsibility, suicide pacts. There is also a class of manslaughter, the involuntary manslaughter. That one, the mens rea is not present. The mens rea of murder is not present. The person kills another person without malice aforethought. Thank you very much for watching Legal Mindset at the Bar. I urge you to subscribe, share with your colleagues if you find this information helpful.